Masechet Baba Kama Daf Sadi. We're discussing Takanat Usha. We learned already that from the letter of the law, a woman who owns property, field, or slaves that she brings into the marriage as nichse melog, meaning she retains ownership of it. Now, during the marriage, the husband can get the produce. That's his right to take the produce of the field, or whatever the slave does or makes goes to the husband, but she retains ownership rights such that upon divorce or his death, she gets the land back as is. Whether it's worth more or less, she gets it back as is. Now, from the letter of the law, if she dies first, then the husband inherits the property. If during the marriage, the woman decides that she's going to sell the land, so the original law before the takana is she has a right to do so, and that sale is valid, and she takes the money and she can do whatever she wants with it. However, the rabbis at Usha decided not so, since at the beginning of the marriage the husband had the expectation that he's going to enjoy the fruits and that he will inherit the land if she dies first, or the property, or the slaves. So then, since that is his expectation, therefore the rabbis do not want the woman to sell that property during the marriage, and therefore they say if she does sell the property, the husband has a right to go to the buyers and take it back. So basically, she cannot really sell the property. That is takanat usha. There is some discussion about whether this enactment ever really existed or whether it really applies, and that's where we begin our discussion. Lema takanat usha tana'ehi. It seems that whether or not there is such an enactment at usha is a machloket tana'im between the following two contradictory baraitot. Tetani chadav demilog yosin beshen be'ayin la'isha v'lo la'ish v'tanya idach lo la'ish v'lo la isha. The first baraita says that if a woman brings slaves into a marriage and someone knocks out the tooth or eye of the slave or any other limb that is not going to grow back. Now, the general law is only if the owner knocks out the tooth of the slave, then the slave goes free. If a third party knocks out the tooth of the slave does not go free. We're talking about Evet Kena'ani. So the question here is, who is the real owner? The first opinion says that if the husband, both opinions agree that if the husband knocks out the tooth, the slave does not go free. So both baraitot do not recognize the husband as the full owner. The question is about the wife. The first baraita says that if the wife knocks out the tooth or eye of the slave, then the slave does go free, but not if the husband does. And the other baraita said, not the husband and not the wife. If either one of them knock out the limb of the slave does not go free. We're going to see four explanations for this machloket. The first one is as follows: Sebaru dekula makinan perot lav kinyan haguf tameh. Maila behakami palge demanda mar laisha let letakanat usha umanda mar lo laish velo laisha it letakanat usha. The first explanation is that everyone agrees that ownership over produce is not like ownership over the item itself. That explains why the husband, who only has ownership over the produce, right, whatever a slave will produce, is not an owner of the slave itself. And therefore, everyone agrees that if the husband knocks out the slave's tooth, the slave will not go free. What is the machloket between them regarding the wife? It's based on this. The first baraita that says that if the wife knocks it out, the slave does go free. He does not think that there ever was a takana of usha. What's the connection? Well, just like from the letter of the law, before the takana, without the takana, the wife is allowed to sell the slave, so she has full ownership rights since she can sell the slave anytime. Therefore, if she knocks out the tooth, the slave goes free. Whereas the second baraita that says even if the wife knocks out the tooth, the slave does not go free, it must be that opinion thinks that there is an enactment at Usha. And just like the wife cannot sell the slave, and if she tries to sell a slave, the husband can go and get it back. So she does not have full ownership rights. Therefore, same consequence of that, if she knocks out the tooth of the slave does not go free because she is not considered fully the owner. So it seems that whether there is a takana or not is what differentiates these two baraitot. That's explanation number one. But then we reject it. Lo dekula ma'it lehu takanat usha. We want everybody to be on the same page. And everybody can agree that there is such an enactment. Ela kan kodem takana, kan lachar takana. The first braita was taught before the enactment was instituted. Usha, city in the Galilee where the Sanhedrin gathered, but there were already Tanaim teaching things beforehand, and so before the takana, the woman has full ownership of the slave and can sell it, and therefore knocks out the tooth. The slave goes free. And the second braita is taught after the takana, when the woman does not have the right to sell the slave, and therefore is not the full owner. And if she knocks out the tooth, the slave does not go free. A third interpretation. Here again, according to the third explanation, everybody agrees that there is a takana, and both braitot are taught after the takana. So, according to that, we have to explain the first braita. Right? Second braita is evident. The wife cannot sell, and therefore the slave does not go free. But the first one, why would she have the right to why would the slave go free if she knocks out the tooth, if the wife does not have the right to sell the slave? Sounds like she's not the owner. And the answer is Rava, De'amar Rava, Hekdesh Hametz v'Shichrur Mafki'in Midei Shibud. The first one is following is an agreement with the rule of Rava. Rava said that in the following three cases, a lien on an object gets undone. The first one is hekdesh. Let's say I owe you money, and I say, listen, and I want to take this animal here. You have a lien on the animal. If I don't pay you in time, you can come and collect this animal. And you agree, fine. So now you have a lien on the animal. In the meantime, I go ahead and I make this animal hekdesh. I'm going to bring this animal as a korban. So what happens? It becomes a korban. It becomes hekdesh, and now you cannot take it anymore. Your lien is undone, right? And I have a right to do that. We don't say that, well, you already have a lien on it, and just like I can't make hekdesh your animal, you might think I cannot make hekdesh an animal that you have a lien on. But Rava says not so. I can make it hekdesh, and you lose your lien. Same thing with chametz. If I owe someone money, and I tell them, listen, this chametz here, this bread will be you have a lien on it, and then Pesach comes, and now the chametz is valueless. No one can benefit from it. It can't be even bought or sold. So now the lien is on an object that is worthless, so the lien goes away. The prohibition of hametz removes the lien. And the third one, which is relevant to us, is shichrur. If I owe you money and I say, here, you have a lien on this slave, and then I free the slave goes free, and your lien is abrogated. We don't say that, oh, you have a lien on it, so therefore the slave cannot go free. So all these things that undo it. What's the connection to this? The connection here is that we're talking about after takanat usha, so therefore the wife that brings the slave a milog into the marriage cannot sell the slave. That's true. But if she sets the slave free, see, the husband has a lien on the slave, right? Basically, he's saying, I can use the slave, and I get the slave after you die, I get to inherit it. So the husband has a lien on it. So since he has a lien, the wife, just like a borrower cannot sell, a borrower can sell land that has a lien on it, but the lender can go and take it back from there. So the lien remains. But just like here, just like in Rava's case, if I owe you money and you have a lien on my slave, I cannot set the slave free. So too here, the husband has a lien on the slave of the wife. Now the wife can't sell it, but she can set it free. So if she knocks out the tooth of the slave automatically goes free, and that undoes the lien of the husband. And that explains the first braita, why the husband who only has a produce does not own the slave. So if the husband knocks out the eye, will not go free, but if the wife does, it goes free and undoes the lien. Good, that explains the first braita. Now what about the second braita? Lema de Rava Tana'ehi. We're going to say that the second braita disagrees with Rava and thinks that even if the person sets the slave free, the slave does not go free because there's a lien on it. And here, the wife who knocks out the tooth, the slave will not go free because the husband has a lien. Is there anybody that disagrees with Rava? We say no. Lo dekula amait lehut Rava v'hacha almu rabanan l'shibuda de Baal. In fact, even the author of the second braita would agree with the statement of Rava. And in a general case, if someone lets the slave go free, the lien is abrogated. However, in this case of the takana of Usha, the rabbis made the lien of the husband very strong, stronger than a usual lien. So strong, in fact, that if the wife would let the slave go free or knock out the slave's tooth, the lien still overpowers and the slave remains beholden to the husband who still owns the slave, and therefore the slave does not go free if either the husband or the wife knock the tooth out. All that is the third explanation. And the fourth and final explanation of the difference between these two baraitot. The last opinion is that none of these Tanaim think that there is a takana of Usha, and therefore the wife she could sell the slave if she wants to. So what is the machloket? The machloket is whether ownership of produce is equivalent to ownership of the item itself. Such that, according to the first baraita that says that the wife can, that the slave goes free if the wife knocks out the tooth, thinks that the husband has zero connection to the slave. The husband only owns the produce, but ownership of produce is not like ownership of the item itself, and therefore we leave him out of it. The wife is the primary, and she is basically the owner. And therefore, if she knocks out the tooth, the slave goes free. The second baraita, however, thinks that kinyan perot is kinyan haguf, and therefore the husband, who has ownership of the produce, is a partial owner of the slave. For that reason, if she knocks out the tooth, the slave does not go free because the husband partially owns the body of the slave. And similarly, if the husband knocks it out, everyone would agree that the slave does not go free because the wife certainly has some ownership over the slave. And so that is the essence of their machloket. It has nothing to do with takanat usha. Now this machloket, whether kinyan perot is kinyan haguf, ownership of produce, is that if you have the right to use something, do you have ownership over the item itself? That is subject to actually a four-way machloket that we're going to see in the following baraita. Detanya. Hamocher avdo le'acheru fasak imo menat sheyishameshenu sheloshim yom. You have someone who owns a slave and he sells it to someone else. But the seller says, I want to use the slave for the next 30 days. I'm selling it to you from now, so you own the slave from today. But for the next 30 days, the slave is going to remain in my house, and I get to use the slave however I want. And after 30 days, then everything the slave does will be yours. So here we have a situation where the seller owns the produce of the slave, even though the buyer owns the body of the slave. Now, Rabbi Meir Omer, Rishon yeshno bedin yom o yomaim mipnei shehu tachtav kasabar kinyan perot ke kinyan haguf tameh. The following four-way machloket is going to be related to the following halacha. The Torah states in Shemot Kaf Aleph, וכי יכה איש את עבדו את אמתו בשבט ומת תחת ידו נקום ינקם. If an owner kills his slave, an eved Kena'ani, then the owner gets the death penalty. This itself is quite amazing that one gets a death penalty for killing a Canaanite slave. But here's the relevant law. Ach im yom o yomayim ya'amod lo yukam ki chaspo hu. However, if the owner hits the slave and the slave does not die right away, but lives for 24 hours and only dies after 24 hours, the Yom or Yomaim, 1 day or 2 days, means a 24-hour period from, let's say it was 3 p.m. to 3 p.m. the next day. So that's 1 day, but it can overlap 2 days. Then the owner does not get the death penalty. This is a special dispensation, a leniency to an owner of a slave, and is not true of anybody else. If someone else would go and hit a person, a free person, a slave, whatever, and that person, even though they don't die right away, but they get worse and worse. They never get better. They get worse when they die after 2 days. the one who hits is liable for capital punishment. It doesn't matter that the victim died 2 days later. They never got better. Okay, that's the general law. However, a special leniency for an owner of a slave who hits the slave will get death penalty if the slave dies soon, but after 24 hours, the owner does not get the death penalty because it is his property. That's the law. Now, the relevance to us is, who is the real owner? So to be Meir says, right, we're talking about a case where one guy sold a slave to another so that the seller can use the slave for 30 days, has kinyan perot, but the buyer has kinyan haguf. So who is the real owner that would get this special dispensation? To be Meir says, it's the first one, it's the seller. He gets the special leniency of Yom or Yomayim. Why? Because the slave is physically in his possession, and he has a right to use it for these 30 days. So the Meir clearly thinks that Kinyan Perot is Kinyan Haguf. Whoever can use the slave is the owner for the application of the the seller would hit the slave and he would die only after 2 days. That owner is not liable. But the second guy, if he hit him and died after 2 days, would be liable. Capital punishment. That's to be Meir's opinion. Rabbi Yehuda Omer, Sheni yeshno bedin yom o yomayim mipnei shehu kaspo kasavar kinyan perot lav kekinyan haguf tameh. Rabbi Yehuda says, no, only the buyer, the second owner, the buyer, has the law of yom or yomayim. If he hits the slave and he doesn't die right away, but only after 2 days, then the second guy, the buyer, does not get the death penalty, but the first one would. So he must think that the ownership over produce is not ownership, and therefore the first guy who only owns the produce of the slave is not the real owner. The second one is, because he actually owns the right, he owns the body of the slave. Third opinion, Rabbi Yosef Omer, shenehem yeshnan bedin yom o yomayim, ze mipnei shu tachtav v'ze mipnei shu kaspo, mesapek aleh kinyan perot ike kinyan haguf tameh, ilav kinyan haguf tameh, usfek nefashot lehakel. Rabbi Yosef says both of them, both the buyer and the seller, will be included under this law. If either of them strikes the slave and he doesn't die within 24 hours, both of them will not be liable. Why? One of them because the seller is because the slave is physically in his possession and is using him, and the buyer because he has ownership over him. Now, Rabbi Yosef actually is in safek. He's in doubt whether is kinyan perot like kinyan haguf or not. So he's not sure if the first owner who owns the produce is really the owner or not. But since we're in Safek and we're talking about capital punishment, so anytime you have a doubt, in the case of capital punishment, we're going to be lenient, and therefore either of these two people will not get the death penalty. Rabbi Eliezer Omer shenehem enan bedin yom o yomayim, ze lefi she'eno tachtav v'ze lefi she'eno kaspo. Rabbi Eliezer says the opposite. Neither of them have the benefit of the leniency of Yom or Yomayim. If either the seller or the buyer strikes the slave and he dies eventually, even if they're after 2 days, both of them would deserve the capital punishment. Why? Because neither of them are the owner. The first one, the buyer, because the slave is not in his physical possession. He can't use it. And the seller, because he doesn't own it. He can use the produce, but doesn't actually own it. And therefore, Rabbi Eliezer says only someone who fully owns all the rights to the slave can get the special dispensation, but not someone who has only partial ownership. Good. Amar Rava, my tamad Rabbi Eliezer, Amar Keraki kaspohu, kaspo miyuchad lo. What's the source for Rabbi Eliezer? Pasuk says, because it is his money. Only someone who it's his exclusive property can get the special dispensation. But if he shares ownership, even if he's the owner of the whole body, but someone else has the produce, or vice versa, or even partners, as we're about to see in a second, if there is any shared ownership, then this law will not apply. Who would be the author of the following statement? That Amemar says that if a husband or wife sell property that she brought into the marriage, the sale is invalid. The author follows Amemar's statement here is following to be Eliezer, who similarly would say that in order to sell something, you need the agreement and joint action of all of the owners. But here, if either the husband or the wife separately sell a slave, well, the husband only owns the produce. The wife only sells the body of it, but the husband owns the produce, so neither of them can sell an item alone. Man tana laha de Tanur Banan, who is the author of the following beraita? Mishechesyo eved v'chesyo ben chorin v'chen ebed shel shene shutafin en yosin v'rashe varim she'enan hozrin. Someone who is half a slave. How can you be half a slave? Well, you might have been owned by two partners, and one of the partners freed the slave. Or someone who is owned by two partners does not go free. Such an Eved Kanani will not go free by the loss of his eye or his tooth or any of the extremities that don't grow, that will not grow back. So who is the author of this? Of this baraita? Amar le Rav Mordechai le Rav Asher, hachi amar mishmeh de Rava Rabbi Eliezer he. It must be Rabbi Eliezer, because only if someone is fully the owner of a slave, then the laws apply to him. Rabbi Eliezer, we already said that regarding capital punishment if a person dies after 2 days, and so he would say the same thing here. The law that a slave goes free by knocking out his limb only applies to someone who is the entire master, but this guy is owned by two masters, or only half of him is owned by a master, and therefore he does not go free. Why would that be? Rabbi Eliezer, regarding the law of capital punishment, said kaspo, because he owns him, only someone who owns him fully. So too here, doesn't say kaspor, but says the word avdo, because it is his slave, so it has to be someone who is his slave uniquely, that he owns the full slave, and no one else owns any part of the slave. Only then, if he knocks out the limb, would the slave go free. So this is also the opinion of Rabbi Eliezer. Next Mishnah. Hatokea lechavero noten lo sela. Rabbi Yehuda Omer mishum Rabbi Yosei Galili maneh. Someone who punches another, there's different opinions about what tokea is, but one of the opinions is he punches them, has to pay one sela. This is, we're talking about for embarrassment. There would also be payment if there is damage for the other things, and ripui and shebet for whatever else. But we're focusing now on embarrassment. How embarrassing is it to get punched? One sela, according to Tanakama. Rabbi Eliezer says in the name. Rabbi Yehuda says in the name of Rabbi Yosei Galili, 100 zuz. Sitaro noten lo 200 zuz. Lachad yado noten lo 400 zuz. If someone slaps someone else on the cheek, slapping, you see, is more embarrassing than punching, than getting punched. Even though the damage from a punch might be more than a slap doesn't usually cause a lot of damage, but it is very publicly embarrassing for such a thing. So if someone slaps someone else, they have to pay 200 zuz. If you slap someone with the back of your hand, it's even more insulting, and you have to pay 400 zuz. And again, the injury or the pain will not be very great. But the shame is greater. Saram be'ozno talash bis'aro rakak v'hegia boruko ve'abir talito mimenu pararo sha'isha bashuk noten lo 400 zuz. If someone pulls someone else's ear or pulls his hair, and if it spits at someone, then the spit reaches and touches that person, the victim. Or if you take off someone's cloak from them and you leave them without clothes on in public, or if someone goes and uncovers the head of a woman in the marketplace, all these are very shameful. Again, most of them, these do not cause physical pain or permanent injury or anything like that. The main thing is the embarrassment. So what do you have to pay for boshet? All these things are very, very embarrassing. To be made naked in public, or for a woman's hair to be uncovered in public or spat upon, all these are 400 zuz. Now, here's one opinion here that says the rule is it goes according to a person's honor level. If a person is very important, aristocrat, then it'll be more, and they get spat upon, it's going to be more shame, they're going to feel more shame than someone who's from a low class who gets spat upon, who also feels shame, but not as much. Now, we're going to discuss on the following daf these amounts here. The 400, is that for the high class or is that for the low class? Right, because the Mishnah here gave one amount. It sounds like one amount for everybody. And here it's saying, well, it depends on what class you are. Okay, but that's one opinion. Rabbi Akiva disagrees. Amar Rabbi Akiva, afilu aniyim sheb'Yisrael, rinotan kilu hem bnei chorin she'yadu minichsehem, shehem bnei Avraham, Yitzchak, veYaakov. Rabbi Akiva says a beautiful statement. Even the poorest among Israel, we consider them as if they are aristocrats that lost their money, who they're still aristocrats, and therefore their shame is still going to be a high amount. Why should we treat all Jews like that? Because all Jews are the sons of Abraham, Yitzchak, and Yaakov, and just by that lineage they are nobility. And therefore, even if a person happens to be poor now, doesn't matter. Good person could be poor, but they could still be noble because they come from a noble lineage. And therefore, Rabbi Akiva disagrees with this kelal that it goes by a person's honor. He democratizes everyone from the Jewish nation is treated like nobility, and one has to pay a higher amount. So Rabbi Akiva is going to be a lot more machmir on the perpetrator of the shame. That you have to treat everybody, all Jews, equally, which is just a very, very beautiful idea. And a story of someone who came and he uncovered the head of a woman in the marketplace. They got into some scuffle, whatever, and he publicly embarrassed her. And so the woman came to Rabbi Akiva to be a judge, and Rabbi Akiva says, you uncovered her hair in public, you caused her shame, 400 zuz you have to pay. The assailant said, I need a little time to pay. Can't pay right now. So Akiva says, okay, you have some time. שמרה עומדת על פתח חסרה, ושיבר את הכד בפניה בו כעיסר שמן. גילתה את ראשה והייתה מטפחת ומנחת ידה על ראשה. So this guy, wise guy, look what he did. He waited in front of her courtyard until she would come out. And then he took a jug of oil and broke it in front of her, and inside the jug was only a very small amount of oil that spilled on the floor. What did this woman do? She had her hair covered. She tore off her own hair covering, and she put her hands on the floor to lap up the oil and put the oil on her head so it shouldn't go to waste. Right? In other words, you see that this woman herself was very willing to cause shame upon herself and dishevel her head and remove just for a few cents of oil that she wanted to use that was on the floor. So this woman, you see, is not nobility. Her shame is is cheap. And therefore, he said, I should not have to pay so much. This guy, this was all entrapment. He had witnesses watching this whole scene. And the witnesses came to Rabbi Akiva and said, yes, we saw her just to pick up a few cents of oil. She uncovered her own head. So how much does she care? So the guy said, to that person like this, I have to pay 400 zuz? I understand if I would go and dishevel the princess, then I would have to pay 400 zuz in public. I caused her a great embarrassment. But this woman, she doesn't care about her own shame. I shouldn't have to pay so much. Amar lo amarta kelum. Rabbi Akiva says your argument is worth nothing. Hachober be'atzmo af al pi she'eno rashai patur. Acherim shechavlu bo hayavim. V'akoses netiotav af al pi she'eno rashai patur. Acherim chayavin. Rabbi Akiva said there's a general law. If someone injures himself, even though you're not allowed to injure yourself, you're not allowed to go and gash yourself or cut off your limb. You're not allowed. But if a person does, you don't have to pay. Who are you going to pay? Yourself? And so even though a person is allowed to injure himself, if someone else injures you, they have to pay. And the same thing is here. Even though she is not allowed to dishevel herself and uncover her head and cause herself shame, she should not do that. Okay, but that's her problem. If she decides that she wants to dishevel herself and cause herself shame, oh well, she doesn't have to pay anybody. But even though she doesn't mind being ashamed like that, and she would shame herself for a little bit of oil, nevertheless, someone else who does it, is not allowed, right? If someone likes to bang themselves on the head, so they bang themselves on the head all day, well, they don't get paid. If you go bang them on the head, then you have to pay, right? Even though they were doing it anyway themselves. Doesn't matter. And the same thing is true if someone cuts down his own young trees. This is not permitted. Bal tashchit, you're not allowed to destroy. Nevertheless, if you own them, you don't have to pay anybody because you're destroying your own property. But if someone else comes and destroys your trees, then they do have to pay you for damages. And therefore, it makes no difference the fact that this woman is not so careful about her own honor, the fact that you caused her dishonor, that you shamed her, and she is, even if she's poor, but she is from the children of Abraham, Isaac, Yaakov, she is like nobility that fell on hard times, but you have to treat her like nobility and pay her the 400 zuz. Okay, amazing Mishnah. Question: Ibailuhu mane suri tenan or mane medina tenan? When we said up here that someone who punches someone else, Nabi Yosef Galili thought that you have to pay 100. 100 what? What kind of denomination? Is it the Tyrian coins, which are a higher amount? That was the capital, the main center, where they used coins that were of a stronger denomination, or is it the local dinar, which is only an eighth of the value of the Tyrian dinar? So 100 what? 100 Tyrian dinarim or 100 of the local dinarim? That's the question. The answer is Tashema. Tahu gabra de tekat le lechabre. Ata lekemed Rabbi Yehuda nesi'a. Amar le ha'ana veha Rabbi Yosef Galili. Hable mane suri. Shema mina mane suri tenan shema mina. We can learn the answer from a story of someone who punched his friend, and they came to Rabbi Yehuda Nisi'a, the grandson of Rabbi Yehuda Nasi, to be a judge, and he says, "Here I am, and here is Rabbi Yosef Galili." That's a curious statement. We'll see two interpretations of what that means. Anyway, the point is he's saying, I'm following Rabbi Yosef Galili, and therefore you have to pay 100 Tyrian coins, so we can learn from here that it's the higher amount of 100 Tyrian coins. Now, what does this phrase mean? My hai ana ha Rabbi Yosef Galili says this is I and this is Rabbi Yosef Galili. What did he mean by that? Ilem hachi kamar le ha ana de chazitach va Rabbi Yosef Galili damar mane suri zilhab le mane suri le memre ta'ed naseh dayan. But the first interpretation is ha ana means here I am, I saw you punch him. I am a witness to the fact that you punched them, so I'm going to serve as a witness. And here, behold, we have Rabbi Yosef Galili's opinion in the Mishnah, and that is the halacha. And he says you have to pay 100 Tyrian coins, and therefore, since you have the witness and we have the ruling, therefore go and pay 100 Tyrian coins. So let's say that's what it means. Well, according to that, this Rabbi Yehuda Nesi'ah is acting as both the witness and the judge. Is that allowed? Can the witness also be a judge? We have a rule that he cannot. And the rule is in this Baraita, Batanya. Sanadrin Shirot Echad Sheharaget HaNefesh. Miksatan Nasu Edim, Miksatan Nasu Dayanim. Deber Bitarfon. Let's say you have the Sanadrin sitting there, 23 judges, and right in front of the judges, someone goes and murders someone else. Not a very smart idea to do. It's like, committing a crime inside the police precinct. Okay, but someone does that. Now, they're all judges. They can't all act as judges because you need witnesses and judges to be separate roles. So what do they do? Some of the judges will act as witnesses, and they will testify before their colleagues and say, we saw this person murder. And they'll be cross-examined and everything. You have to go through the whole regular thing. The regular system, even though they are the judges themselves, so they have to separate. Now that's a bitarfon. Rabbi Akiva Omer, kulam adim hem, ven ayed naaseh dayan. Rabbi Akiva says no, all of them are witnesses, and therefore none of them can be judges. They will have to find other judges who weren't there. What's Rabbi Akiva's reasoning? He thinks that the judges have to be unbiased. If the judge was there at the time and saw the thing happening, then they're already biased towards saying that this guy is a murderer. And even though these are trustworthy people, certainly, nevertheless, the judge has to be someone who wasn't there and didn't witness what happened, so that he can be impartial And then he can ask proper questions to the witness. What did you see? What was his intention? What was going on at the time? What did he use? And so the judge has to be totally impartial, because maybe there is a different side of the story that if someone's a witness to it, they will not bring out in their deliberation. Okay, now that's the machloket between the two. But you see, they agree on a fundamental principle. Ad kan lo kamar bitarfon ela demiksatan nasu edim miksatan nasu dayanim. Aval edna said dayan lo kamar. Even the bitarfon is more lenient here, and he says that some of the witnesses can act as judges. They just can't act as both witnesses and judges at the same time. But some of the witnesses will testify, and some of those who were witnesses will not testify, but will act as judges. But even the bitarfon agrees that a witness cannot be also a judge in the very same case at the very same time. And so here, Rabbi Yehuda Nasiya, how could he be the witness and then be the judge and say, "Oh well, I am the witness," and cross-examine himself and therefore give a judgment? Should not be allowed. Of course, not for Rabbi Akiva, but even for Rabbi Tarfon, it wouldn't be allowed. And the answer is Kitanya hahi kegon sherau balayla delalim ebad ninhu. Now, this case of this braita where of the murder, that's where the murder happened at night. Since it's at night, you're not allowed to judge at night. And so at night, they're acting only as witnesses. Therefore, when it comes daytime, now there's a problem because they can't be witnesses and judges. They can't be judges to cross-examine themselves as witnesses also. So there, Rabbi Akiva says you have to get totally new judges, and Rabbi Tarfon says you have to pick a role. You could be judges or witnesses, but not both. But that's because it happened at night. Whereas this story of Rabbi Yehuda Nasiya happened during the day. Now, during the day, one can be a judge. So Rabbi Yehuda Nasiya, watching this, he's watching it as a judge. And the judge, how does he know what happens? Right, he relies on witnesses. But if he himself sees it while he's a judge, that's okay. Right? In other words, a judge can be a witness as long as he is a judge at the time that he sees the item happening. When we say a judge cannot be a witness, that's only talking about where the person witnessed it at night, when they're not a judge, and now they're going to be a second role of being a judge about their own testimony. That's not allowed. But if they see something as in their role as a judge, and they see it directly, then that's okay. And that's what Rabbi Yehuda Nasiya did. That's all one interpretation. Or a much simple explanation that doesn't get into this whole problem is that Rabbi Yehuda Nasiya said, "Here, behold, I am, and I agree with Rabbi Yosef Galili." In other words, here I'm here the judge, and I, as the judge, I decided that Rabbi Yosef Galili, the halacha follows him, and that you have to pay 100 Tyrian coins. And there were also witnesses. The witnesses are separate people, right? So I am here. I follow the opinion of Yosef Galili. The witnesses are right next to me, and they said that you did this, and therefore you have to pay the 100 Tyrian coins. The Gemara next follows up on this law that a witness cannot also be a judge. Is it true that Rabbi Akiva agrees that a witness cannot be a judge? Look at the following. Baraita v'atanya v'ika ish et re'ahu be'eben o be'egrof. Shimon natimni omer ma egrof miyuchad shemasur la'adav v'la'adim af kol shemasur la'adav v'la'adim perash le'sheyasta betachat yad ha'adim. The pasuk talks about if a person hits someone else with a stone or a fist, if they get better, then they later die. Then the person who hit is not responsible. But if they die from that hit by a stone or by a fist, then the person who hits them is liable. So now, why does it specify these examples of a stone or a fist? Shimon Timni explains, just like a fist is something unique in that it is right there, it's attached to the body of the perpetrator, of the assailant, and therefore something that the Adam means the judges. The judges can come and examine it, as well as the Edim can also come and examine it. And they can look and see if this fist, is it likely that this fist hitting a person would cause death? If not, if it's just a small fist and the person died, I guess maybe they're exceptionally weak. Then the aggressor is not liable. But if they see this is a big fist and this is something that could cause death to this victim, then the person is liable. So too, all evidence, any a weapon that's used has to be something that is available to the judges as well as to the witnesses. The witnesses are there, and so they see the weapon, but also has to be brought into court so that the judges can examine the stone or the knife or whatever it is. And this excludes something that left the possession of the witnesses, and it's not around anymore. He threw away the rock, threw away the gun, and it's not there, that can be analyzed by the court itself. So that's what Shimon Timni says. Not only the witnesses, but also the judges of the court have to be able to examine the weapon. אמר לו רבי עקיבא וכי בפני בית דין היכהו שיודעין כמה היכהו ועל מה היכהו אם על שוקו או על סיפר נפשו. Rabbi Akiva rejects this and he says, what, did the assailant strike him in the presence of the court that they would know any of the other details? Like, how hard did he strike him? Did he strike him on the thigh where it would not be deadly, or on the lobe of his heart? It might be an area near his heart, or it could be on his throat. A place would be very sensitive. So the weapon or fist itself is not only what's significant, how big the stone is that he used, but all the other details are equally important to know if the act of the assailant was one that would normally cause death. But you need to know all these things, and the judges obviously weren't there and don't know any of that. So just like there's no way that the judges can directly know any of the other actions of how hard he hit and where he hit, but they rely on the witnesses, so too regarding the weapon, the size of the weapon, the stone, they don't have to see it themselves. They rely on the witnesses. ועוד הרי שדחף את חברו מראש הגג או מראש הבירה ומת, בית דין הולכים אצל בירה או בירה הולכת אצל בית דין, ועוד אם נפלה חוזר ובונה. And furthermore, there are cases where someone will kill someone else without a weapon, but rather by pushing him off the top of a roof or off the top of a building. So now what? Bet Din has to see the weapon. In this case, the weapon is the building. Do the judges have to go out to the building, or do they bring the building into court, right, so that they can examine it? Rabbi Akiva is being very sarcastic here, right? And what if that building has fallen down? Should they rebuild the building the same way it was, so that the judges could go out and see how tall it was, what's the slope, right, what's the angle, and decide if this pushing off someone off this building is likely to cause death or not? Obviously, this is ridiculous, and therefore, just like we do not need the judges to know the details of how hard he hit or how tall the building was or anything like that, the judges don't examine that directly. They rely on the witnesses. So too for the size of the weapon, of the stone, the judges are to rely on the witnesses, and it doesn't have to be there in court directly. So that's how Rabbi Akiva rejects Rabbi Shimon HaTimni. Now here's the question. Rather, just like a fist is something that is submitted to the witnesses. The witnesses can see the fist of the assailant. So too, whatever weapon that is used, the witnesses have to be able to testify that they saw that this knife that he used or that the rock he used is one that could kill, is likely to kill, and therefore that person is liable. Only the witnesses have to know, but not the judges. This would exclude a case where the stone is no longer in the possession of the assailant, and we don't know where it is, and even the witnesses didn't see it. They didn't have quite the angle. They saw from behind, and they didn't see the stone itself. If the stone is still there, and then they can go and see it, that's fine. But if he hit someone and threw it away, and we don't know where the stone is, and even the witnesses don't know where it is, then the person example. As long as the witnesses can identify the stone and saw that it is one that is big enough to kill a person, that's all you need, and not the judges. Okay, that's all what Rabbi Akiva said. Now, here's the question. Katani mihat amar lo Rabbi Akiva v'chi bifnei betin hikau sheyudin kama hikau ha'ikau bifnehem ed na'aseh dayan. In Rabbi Akiva's questioning of Rabbi Shimon HaTimni, he said, rhetorically, right? Did the striking happen in front of Bet Din that they know how hard he hit him? So he said, it didn't happen, and that's why. Obviously, the Bet Din does not have to witness it. But we can infer from that question that, let's say, the judges, in fact, were present at the time of the injury, then they could be witnesses to it as well as judges. So doesn't that mean that, according to the Rabbi Akiva, a witness can also be a judge? And the answer is no. Lidvarav de Rabbi Shimon HaTimni kamar ve'let la sevira le. Rabbi Akiva was only saying a statement in accordance with the opinion of Rabbi Shimon HaTimni. They were taking Rabbi Shimon HaTimni's assumption, and Rabbi Akiva was taking it ad absurdum. If you think that the judges have to know, have to see the weapon, then do they? Well, they're not there. What about everything else? Wouldn't they have to witness everything else? Right? Are they there? Are they present that they would be able to witness everything? Obviously not. So this was just part of an argument against Rabbi Shimon HaTimni, but Rabbi Akiva by himself does not think that they need to be there, and in fact thinks that they cannot be there. If the judges are present at the injury, then they are witnesses, and then they are disqualified from being judges. So in fact, Rabbi Akiva does not think that witnesses can be judges. Now, last related halacha tenor banan shortam shemit v'hizik danin oto dine nefashot v'en danin oto dine mamonot. A shortam that did two things. It killed someone and it caused monetary damage in two separate incidents. Now, for killing someone, even the shortam will get the capital punishment. For doing damage, the owner has to pay half the amount of the damage, but only from the body of the shortam itself. He doesn't have to pay any more than the shortam itself is worth. So now, since the shortam did two things, so is the owner going to be liable for both of those things? And the answer is no. You bring in the ox to be judged for capital punishment, but not for monetary. Why? Because once it's judged for capital punishment, now it's like if it's deemed to be liable. So now it's going to be sentenced to death, the ox, and the ox therefore is not worth any money, because it's going to be killed. And so once it's not worth any money, so then the owner will not have to pay anything from the body of the ox, and he doesn't have to pay anything out of pocket because his monetary liability is limited to the value of the ox, and now that the ox is going to be killed, it's not worth anything. Mu'ad shehemit v'hizik danin oto dine monot v'chozin v'danin oto dine nefashot. However, for shor mu'ad, who also does two things, it kills someone and causes damage, shor mu'ad also gets capital punishment for killing. And for the monetary damage, shor mu'ad, there's unlimited liability of the owner. The owner has to pay from the best of his land. It's not limited to the body of the animal. And therefore, in that case, you'd bring the ox in for judgment first of the monetary amount that it did, and the owner has to be present for whenever his ox is being judged, and then you bring it again for the killing, and that way the owner will have to pay for the damages, and also will then, if it's found guilty, the ox will be killed. But the other way around, the other order will not work. If they first bring him in for judgment for capital punishment, and then that's it, it's going to be killed, you cannot then bring it in for judgment for capital for a monetary case. And the question is why? Even if they first bring it in for the capital punishment, so what? So let them bring it in also for dineh mamonot. What's the problem? Rava says, I found the sages of the yeshiva, and they were sitting and they explained the halacha as follows. This is the author of this Baraita, Rabbi Shimon, who says just like a fist is something that is available to the judges and to the witnesses, so too, whatever did the damage has to be available to the judges and the witnesses. Witnesses, of course, everybody agrees to that, but his chidush is that has to be available to the judges. Applying that to this case, the ox that killed or injured has to be available to the judges to examine the ox. And herein is the problem. Alma ba'inan umdena de be'edina. So we need the betin to come and evaluate this ox, right? What kind of ox is it? How big is it? Is it likely that it would have killed, that it would have caused damage? But this ox, once they judge it for capital punishment, so it has to be killed. It has to be killed right away because we cannot delay judgment. This is a law for capital case for human beings, that if a human being is declared that he deserves capital punishment, it's not right to delay it. Psychologically, a person knows that he's going to be killed, and you delay it, even a week, even a day, then he's suffering that whole time. And even though the person is liable capital punishment, we want to be merciful and kill him right away. Now, this really technically wouldn't apply to an animal because the animal doesn't know that it was just given a verdict of capital punishment. But nevertheless, we compare the two, and we say this applies to an animal as well. And so therefore, if you judge the animal for capital punishment first, then we cannot go into delay it, and we're going to kill it right away, and it won't be available for the Bet Din to examine. And Rabbi Shimon Timni says that the thing that did the damage, the ox, has to be available to the Bet Din during the process, during the court case, and it won't be available for the monetary court case. But if you do it the other way around, then that's fine. They'll examine it for the monetary case, decide, okay, you have to pay $1,000, and then they'll bring it back in and decide the capital case. That way works. Now, Rava heard that explanation, and he said, "Amina lehu ana." I can explain this baraita not only according to Rabbi Shimon, but even according to Rabbi Akiva, who does not think that the weapon, that the ox needs to be there. And we're talking about a case where the owner ran away. In other words, the animal was decided of capital punishment, and then it was going to be brought in for monetary payment, for monetary judgment, and he realized he was going to have to pay a lot of money, so the owner ran away, and you can't judge a case without the owner there. And now the question is, well, in the case where they did the monetary first, and you said, oh, that's okay, you could do the monetary first. If they didn't do the dinei nefashot yet, how can they even do the monetary, even if the monetary is first, without the owner? In other words, assuming that the owner runs away, he runs away in both cases, no matter whether the mamonot was first or last. So then how would they ever judge the mamonot at all if he runs away? And the answer is the kabel sahate ubarach, that the witnesses came in when the owner was there. And the judges heard the testimony, so they did most of the procedure while he was there, and that's fine. So the procedure goes well. But the problem is that he runs away and then can't pay anything because he takes all his property. So all they have is the ox there. So there's nobody to pay. Since there's nobody to pay, there's no point in going ahead with the judgment, with the monetary judgment. So in the end, so how is anybody going to pay anything if the owner ran away? And the answer is from plowing. Since they have the ox, they'll rent out the Bet Din will rent out the ox until it generates enough money to pay for the damages. Well, if that's true, then we can apply the same thing to a short tam, right? Why'd you say that a short tam only has the capital judgment, but there's no monetary judgment at all? Why not do the same thing and let it be judged for the monetary damages that it caused and rent it out? and it'll produce from itself, right? This is from the body still of the animal, and it will produce enough money to pay for the damages. And then after that, you judge it for the capital case, and then you go and take it out to be killed. So why can't for a short time you do both? Amar Amari bered Rav Kana zot omeret iridiya aliyah demarahu. So Mabidi, son of Rav Kana, explains that we learn from here that plowing is considered the same as the aliyah, the superior land of the owner. In other words, when for a short time there's limited liability, the owner only has to pay up to the value of the body of the animal, right? Take the animal and sell it on the market, and that's the max he has to pay. Whereas the use of the animal for plowing, that's above and beyond the value of the body of the shortam. That is similar to the owner having to pay from his own pocket or from the superior land that he has, right? Whatever he has to use to pay for injury, which is only true for a short mu'ad, not for a short tam. And therefore, this idea of paying both by having the animal plow, and even if the owner ran away, having it plow and only then giving it capital punishment, that only can apply to a shor mu'ad. But for a shor tam, one only pays from the body of the animal, and therefore once there's capital punishment, then the animal is worth zero. So there is going to be nothing to pay for the damages. Baruch Adonai le'olam, amen ve'amen.